Well, hello, everyone. Welcome to the next installment of the Beverly Hills Bar Association Startup Law Initiative. My name is Jennifer Goldstein, and I'm your moderator today, and I'm joined by your presenters, Jeffrey Bills and Lynn Hook, two esteemed and fabulous employment attorneys here in Los Angeles. And we are covering the topic of employment, hiring, maintaining, and terminating employees. I'll give you a bit of brief background on all of us, and then we'll go ahead and get started. So again, my name is Jennifer Goldstein. I am an attorney at Michelman and Robinson LLP here in LA. We have offices all around the country as well. I am not an employment attorney, actually. My bread and butter is general civil litigation. I'm trying to specialize in blockchain litigation, so totally different, but I'm sure one day it'll touch on employment issues. We do have an employment department here. So that's about me. And then we have Lynn Hook, who is a founder of Employer Lawyer PC. She advises and defends employers and has done so for 25 years. She was in-house employment counsel for a Fortune 500 hotel chain with 70,000 employees. And she is very familiar with all things employment, wage and hour, human resources policies, discrimination training, workplace investigations, the works. And we're also joined by Jeffrey Bills. He's an attorney at Bibian Law Group, and he represents employees in PAGA and class action matters. He's represented employers as well in litigation and defense and has advised employers throughout his career. He's also on the board of governors of our BHBA and a former chair of the Labor Employment Law Executive Section Committee. So welcome everyone once again, and I'm going to turn it over to Lynn.
All right. Thank you, everyone, for joining us. So nice to be with you virtually. And we'll move to the first slide and we'll talk about our first topic. So we'll just start out with the basics. I'm sure many of you are either just getting off the ground, or maybe you already have a couple of employees and you have some questions already. Or you're thinking about starting a business and you just kind of want to get things organized before you do that, which is a very good idea. So who are employees under California law? Well, the Labor Code tells us that the employee is someone who is in service of an employer, and it's a very broad rule. And it's something that you do want to think about. We sometimes get questions about whether or not an individual could be an independent contractor versus an employee, and what is the difference. And I explained to employers that an employee versus an independent contractor is not a choice, it's a legal distinction. And so under the ABC test, which I think maybe Jeffrey can go into, we do try to be very careful as an employer advisor to be sure that most of the individuals working in the entity are going to be classified as an employee. But maybe Jeffrey wants to walk through the ABC a bit with you.
Yeah, so this has been a highly litigated area and an area of changing law. And like Lynn said, you would think that it would be so simple to say, oh, who's an employee? Well, it's the people I hired. But a lot of people really do want to classify their workers as independent contractors for whatever reasons. Sometimes the workers themselves would like to have that designation. But California affords a lot of protections for employees that provide a lot of benefits that sometimes I think people lose sight of. And part of California's effort to make sure that workers actually have the benefit of these employee protections is implementing this sort of somewhat difficult test to pass occasionally about whether you can classify your workers as independent contractors or not. And we now have this ABC test, which comes into play in a way that it didn't used to just a few years ago, quite to the same extent, in order to be the only way that you can be an independent contractor in many circumstances is if you meet all three of the ABC factors. Part A requires that the worker is free from the control and direction of the hiring entity in connection with the performance of the work. So basically no control. Part B, and these are all of these have to be met. Part B is it requires that the worker performs work that's outside of the course of the hiring entity's business. So that can be difficult if you are trying to do software consulting and you're trying to hire a software consultant as an independent contractor. You've failed to meet that Part B of the ABC test. Part C requires that the workers customarily engaged in an independently established trade, occupation, or business of the same nature as the work performed. These are kind of nuanced tests in a way. It's always best if you come to this decision, especially as a startup, to get employment counsel like Lynn. It might seem like, oh, why do I want to pay for an attorney? But believe me, it's a lot less expensive to pay for an attorney for advice and counsel than to pay them to defend you in litigation. Anyway, I probably spoke longer than I needed to on that topic. So next slide, I guess.
Yeah.
Huh?
One of the protections of California law is that we do recognize at-will employment in the state. So that means that unless you have some kind of a contract with terms or specifics, generally an employee will be viewed as at will. And so as an employer advisor, I always recommend that the offer letter, the handbook, the materials all reference at-will employment, which basically means that the employer or the employee is free to terminate the relationship at any time and that no reason need be given. Obviously, you don't want to be making decisions that are discriminatory or illegal, but though for the most part, if you're letting someone go, you don't have to give them a specific reason. Now, that wouldn't necessarily be my advice. Of course, it's always a good idea to document the file for performance and so forth, but generally, employers in California need to be sure that they are preserving that employee at-will relationship by not making recommendations or representations that this will be a long and fruitful relationship, or we hope you work here forever. Things along those lines are not statements you want to make. And Jeffrey may have some thoughts on that as well.
Yeah, I mean, at-will employment is sort of the presumption, and a lot of times when I was advising employers, one thing that I would say is that to the extent that you're going to terminate an employee, just keep a record of all, keep something in their personnel file to contemporaneously document the work-related, the legitimate business-related reasons for the decision, because at-will means you can, terminate for any reason or no reason at all, as long as it's not an unlawful reason. And the trick is that when it comes time to prove that you didn't have an unlawful reason, or that there was some legitimate reason, or whatever the burden of proof is going to be in that case, it's better if you've got the documents to back it up. Another element of this is that sometimes, especially newer employers, startups might think, well, you know what, I'm going to put some stuff in there to kind of guide the decisions that I make with regard to when I'm going to discipline, what's going to happen. And the more you build that in, the more risk that there might be that it might be construed as something that modifies the at-will nature of the employment. So again, to the extent that you're building any of that in at the start of your business, worthwhile to talk with employment counsel. Lots of potential pitfalls.
And we had a good question from one of our participants about whether or not attorneys that only have one client can be an independent contractor. So I think what the participant is asking is, if I consider myself an outside attorney, but I only represent one employer, for example, or one entity, am I an employee of that entity, or am I an outside contractor? So one of the tests is that you are part and parcel of the reason that business exists. So, the widget maker, if you're a widget maker for a widget company, you are going to be an employee. But if you are an outside advisor and you have your own independent business, and there are other tests that would apply there that we can't go into in the time we have today. But if you are an independent advisor and you are outside and you maintain your own malpractice insurance and you have your own practice and you hold yourself out as available to other entities to hire you, whether or not you actually have other clients, that would be a better fact for you. But If you hold yourself out as available to other clients, then you could be considered independent. But typically, if you have an attorney that is functioning really only on behalf of one entity, and that attorney is perhaps even sitting in-house, the attorney should be on someone's payroll. You wouldn't necessarily have to be on that company's payroll, but you might be under some kind of outside entity, kind of a third-party attorney provider or something. But generally, it depends on the level of involvement for that attorney in that situation. Okay, we can go to the next slide now. So a written offer letter. I will see that some clients don't use any offer letter, particularly in the restaurant business. Some businesses where there's a lot of turnover, they don't want to get bogged down in documentation. So some years ago, California passed a rule that we have to use this notice to employee. It's under Labor Code 2810.5, and it's a 2-page document that you can get off the internet. And it basically takes the place of an offer letter, if you will. It provides the basics about the legal name of the hiring employer. So the individual is very clearly aware of who they work for, and their address and telephone number, and then specifically their wage information. So their rate of pay, their overtime rate, what their payday is. And then page 2 actually provides for paid sick time, workers' comp, carrier, and that sort of information. Now, if an employer prefers to use an offer letter, all of this information can be wrapped into an offer letter with whatever other language you want to include, like at-will language, maybe confidentiality, things like that. But yes, California does require that there at least be this notice to employee for a non-exempt employee.
Yeah, and I'll just share that this sample form that's provided by the state of Illinois, it's not a required form, but it's put out there because the state, I think, really wants to make sure that this information is being disclosed. It's part of what's called the Wage Theft Protection Act. And you can tell from the name of that law what they have in mind. The idea is that, okay, maybe there have been employers out there that haven't been giving all the information and maybe stealing wages without giving employees the opportunity to know how much they're actually being paid or who they're supposed to talk to or what their entitlements are. So when I was advising employers, I did have some employers that didn't necessarily want to use a form that the state provided for them, and that's fine as long as the employer knows that each of these things is required statutorily to be disclosed. And if you don't disclose it, then you can face litigation, get sued by someone like me on plaintiff side now, saying, hey, this Wage Theft Protection Act form that you filled out is non-compliant. So with regard to an offer letter, I tend to think that offer letters are often a good opportunity to set forth what the terms of employment are. But again, like Lynn said, it's always best to confer with your employment counsel to make sure that you're doing only what you need to and not necessarily causing a problem where you don't need to cause one.
And California, of course, was one of the first states to require this type of notice under the Wage Theft Prevention Act, but many other states are following suit now. So if you happen to be doing business in multiple states, I'll just note there that your employee is governed by the city and state where they work. So if you have employees that work in Chicago remotely, for you as a California entity, they are governed by Chicago law as well as Illinois law, and of course federal. So one of the challenging parts about having a fully remote workforce is that you have to be aware of and apply the laws across the United States. There's also a lot of tax issues that go along with payroll and so forth. So sometimes I get questions about, well, I just want everyone to be remote. I don't care where they work. It's easier said than done, I will tell you. Not that California is necessarily where you want to be an employer, but it's just something to keep in mind as you start building your business.
Yeah.
Okay.
Wage Theft Prevention Act. I might have said Protection. Prevention Act.
Very similar names. They could be slightly different in other states as well. So, okay, we'll go to the next slide. All right, employee interviews. So very important to recognize that when you interview an employee, you are certainly engaging in potentially a discriminatory act. And I hate to say it that seriously, but it's very important that you make sure that anyone who is doing interviews for your company has at least some basic training or understanding of our discrimination harassment prevention laws in California. That could be because you've already put them through harassment awareness training that's required under California law. But as we ask questions of an applicant, we need to be thinking about respecting their rights. So you want to avoid subjects such as what wage rates they've earned in the past. You can ask them what wage they're looking for in the future. You cannot speak about former wages or current wages at a current employer. And again, if the employee offers it up, it's okay, but I wouldn't ask questions about it. You want to be aware of protected categories. Those are the many enumerated categories under California law that we avoid discussing personal information about in employment interviews or making any decisions involving those categories during employment. So you don't want to ask what year did you graduate from college, because although you may not mean it that way, it might tell you how old that individual is. And obviously anyone over the age of 40 is covered against employment discrimination under federal and state law. Whether someone is married, marital status is a protected category under California law. Do you have children? That could suggest you're asking questions about whether or not one has obligations outside of work, and could create a host of all sorts of issues. Ask things like, tell me about your educational background. Open-ended questions are always going to be more helpful. What salary are you looking to earn, or what hourly wage are you looking for? Why are you job searching? That's a fantastic question, because you want to understand why this individual is looking around. And it will certainly shed light on who they are and with the answer that they give you. And certainly ask detailed questions about, what hours or days are you willing to work? You don't want to hire someone and then find out they're not willing to work on Saturdays, which is when you specifically need them. So just some suggestions there on interviewing.
Yeah, the pay equity issue, I think, is one that has gotten a little more prominence in recent years in California. And Lynn mentioned this, but just to highlight that you might think that this is an okay question, but you can't ask, what are you earning now? Or any salary history information. And the idea, it ties in a little bit with laws that are seeking now to counteract the pay inequity that has been kind of perpetuated for years, in part because previous salaries would be carried over. And so it is okay to ask for salary expectations, but especially as a startup, this is just an area to be a little mindful of. Any of these questions in general, again, the question, I think it's probably safest to gear questions towards what do I need to know about what this person can do to perform the work and do a great job. All the other stuff is kind of extraneous. What did you earn before? Are you married? That stuff, like Lynn said, can be a problem.
All right, next slide. So what about employment agreements? Particularly if you have worked maybe for a large corporation, or maybe if you were in a C-suite type role, you might have had an employment agreement elsewhere. And so you might think that you want to have contracts for all of your employees. This is typically not my advice. I would typically only recommend an employment agreement for executives, or someone where you need to offer equity, or you want to define severance or have specific termination reasons. So usually we recommend for most employees an offer letter, maybe a confidentiality agreement, maybe an arbitration agreement. Certainly make sure that the non-disclosure agreement you're using is appropriate for California employees. You might want to state again whether there's at-will employment involved there. And then on the topic of arbitration agreements, we've had a significant decision in the last month from the Supreme Court in the Viking River case. So in this situation, California employers do need to understand that arbitration agreements are not mandatory for employees. They are optional to sign. And there's also several other provisions that need to be in there now. Arbitration agreements do not cover sexual harassment, sexual assault. So although you may want to use them, you also want to talk with your employment advisor about whether or not arbitration is truly a cost-saving measure, because typically the employer has to pay the arbitration fee above any court fee that would be paid by the employee. So sometimes arbitration ends up being a very expensive prospect. It might be more expedient. You may not need to worry about a runaway jury, but it's not really an easy answer either. So you do want to get some good advice and decide whether or not that's the right fit for your type of business. And in any event, an arbitration agreement should be separate from any other offer letters or agreements the employee is signing.
Yeah, these typically what I've seen very often are standalone confidentiality agreements that an employer will want to have because of the nature of their business and the types of confidential or trade secret information that the employee might be exposed to. And it's always important to remember that even though that's a standalone agreement, it's important to probably put in there somewhere that it's not going to alter the at-will employment status that we talked about earlier, because any agreement like this is obviously going to touch on the terms and conditions of employment, at least to some extent. The ARB agreements, it's just been a fascinating area of a lot of change, including the Viking River case that has to do with arbitrability of Private Attorneys General Act, PAGA claims. If you're a startup, you may have heard this word PAGA and known that it means something very frightening. But this Viking River case, just in case you're aware, there's been I believe, a petition for reconsideration. So we're going to see what happens with it. And I think that there are some potential laws afoot in California. It's still an unsettled area of law. In terms of the ARB agreements, one thing that it depends on how big you are, but sometimes the arbitration agreement, even employers who have one, even if it might be enforceable, they will make a strategic decision to allow a litigation to go forward in court on a class basis for the purpose of arriving at a class settlement. And in that case, arbitration isn't going to help you much. So, I mean, there are a lot of considerations. Sometimes after an arbitration agreement is implemented, then the employees, if they really are having problems, you'll have one after another. You'll have massive numbers of arbitration demands, and then all of a sudden it's like, well, what value am I getting now? It can be a really tricky area, and there are specific, in the employment arena, there are specific provisions that any arbitration agreement has to have so that it's not unconscionable, because the unconscionability analysis of any arbitration agreement in the employment context is going to be fairly heightened. Anyway, this is maybe more information than you need. As a startup, talk with counsel. Again.
Okay, next slide. So if you're going to use an employment agreement with an executive, you do want to make sure you're hitting some basic key points on, the term of employment, the comp and benefits that you're going to be offering. If you're a small business, you do not have to offer healthcare insurance, for example, but typically you might want to either offer a plan, or maybe you're going to offer a stipend or some kind of lump sum in place of a plan. Obviously, you want to work with your corporate counsel on the equity terms. Again, we talked about confidentiality and arbitration. I always remind startups that under California law, your corporate officers have to be employees of your entity. So sometimes I'll be introduced to a smart startup business, and I'll ask them to send me their employee roster, and they might tell me they don't have any employees because they're all contractors, or none of them are taking a salary, or along those lines. So there are some specific rules under corporate guidance and tax rules about employment status. So that is something you do want to keep in mind. But, as you're planning to grow your business, you do want to get good advice on what do those employment agreements have in them? What kinds of equity are we going to offer the individuals joining, and work through those details. All right, we can go to the next slide. So what are those legal responsibilities of the employer? Well, I don't want to be the bearer of bad news, but there's probably 25 or 30 California laws that apply to you if you have less than 5 employees. So it is really important from the get-go, as soon as you establish a business, to get some good advice on the materials you need to be reviewing with your employees and what you're required to provide to those employees. You are obligated to withhold payroll taxes, as you know, as well as all those other withholdings, federal, state, local taxes that might be applicable. And you want to make sure that your employees are clocking in and out appropriately if they're non-exempt. So when we say exempt, we mean exempt from overtime under the rules. And the wage order, which we might talk about down the road here in this presentation, the wage order will explain when an employee can be exempt from overtime purposes. If they are not exempt, meaning they are obligated to receive overtime or eligible for overtime, you really want to make sure you're using appropriate documentation, whether it be a timesheet that they fill in every day with actual start and stop times, or they're using a punch clock or what have you. But I tell employers that, you know, payroll is really like an ATM. The information that goes into payroll is what comes out on the paycheck. So we need to make sure as employers that we're paying our employees fairly and that we are giving them a very clear pay statement and being very obvious about any kinds of deductions or withholdings, and certainly being very open to questions from employees about their pay, because they do have a right to understand how they're getting compensated.
I'll just add a little bit to this. The timekeeping requirements for California employers and the record-keeping requirements, this is going to go to the heart of a lot of potential liability for class action or PAGA representative action claims. And one thing to be aware of is that if you as a startup, as an employer, if you do not have good records of when people clocked in and clocked out, and time records, you may face the presumption, if it comes to litigation, that your employee's reasonable estimate is going to be given weight. So it's not.
I think we froze. We'll keep going. Okay, let's go to the next slide.
When he or she asks to look at them, and so forth. So just kind of important. One of the really quick tangent without getting into the weeds is that it ties back in a little bit to the earlier discussion about what is an employee, because the various requirements and who's going to be subject to them is going to depend a little bit on the context. Your workers' comp carrier might have a different idea than you do about whether that person is an employee and should have been in your workers' comp policy. And believe me, if you get an audit by your workers' comp carrier, it's not going to go well if you haven't really thought this through. I've seen this happen. You know, the definition of who's an employee is going to depend on the area of law, and each of these areas has specific record-keeping requirements. So anyway, again, don't want to get into the weeds, but lots to think about as a startup.
So what about interns? It's the summer and we often get questions about whether or not an entity can hire some interns to do some free work. So, you know, I typically say that if the employees, because they are going to be looked at as an employee under any circumstances, unless they truly are not doing any work for you. So if it's an observation type role, or they're shadowing, or they're sitting in on meetings, and they're not actually performing specific duties, that's probably legitimately able to be classified as an internship. The ground rules really look at it as more of an educational opportunity and whether it primarily benefits the individual or the company. So if the relationship primarily benefits the company, then I would recommend you put them on at least minimum wage and pay them by the hour. So that's usually the safest way to do it, is to pay minimum wage. Um, Many professional firms bring in someone who maybe doesn't even have the educational background to be able to do the work per se. So maybe in that case, you're really just educating that individual and you're really just letting them see kind of what your business is all about. Maybe in that case, it's okay to be an unpaid intern. You do want to have a written agreement though with that individual, just to clarify this understanding and the details of the role. If they're not yet 18, remember they've got to comply with labor code and education code requirements. So I would say typically interns today, it's a lot more scrutinized than it used to be. But if you truly feel like they're not actually doing day-to-day work that would otherwise be done by someone else, then you do not have to pay them.
Yeah, if you're employing minors, really pay attention to what the school is authorized. You're going to have to fill out some paperwork, especially during the school year when school is in session. There are restrictions on how many hours these employees can be required to work, and it depends on their age. And it can be easy, I think, sometimes for employers to forget about that. So just highlight that as a thing to be aware of.
Yeah, I had a client recently who told me that he had a employee who brought his nephew in to work, just to kind of learn the business a little bit, see what was going on. And, he was doing very simple tasks. So the employer didn't believe it was an employment relationship. And lo and behold, he now has a demand letter from the father of the individual, claiming that he didn't have the appropriate paperwork from the school, that he didn't have the work permits, he wasn't paid a minimum wage, he didn't track his hours, so on and so forth. So, just something very important to keep in mind if you're employing anyone under 18. Okay, next slide. Okay, timekeeping. So we touched on this briefly, but when we talk about misclassification, sometimes we're talking about those employees, whether they're contractors or employees. Other times we're talking about whether someone is exempt or non-exempt. And we defined that earlier to mean that if someone is exempt, they're exempt from the overtime rules. That also extends into other areas, because if someone is considered hourly, they need to be recording all those in and out punches. They need to be compensated for overtime over 8 hours in one workday and 40 hours in a work week. There's also a double time rule in California. So anytime any employee who is hourly works over 12 hours, they get double time. And then if they happen to work 7 consecutive days, they are getting overtime for the first 8 hours and double time for thereafter. So do make sure your timekeeping is valid, even if you're a small business. Very important to have the employee clock in and out, even on a paper basis, and pay according to those punch records. Meal periods and rest breaks are probably something that Jeffrey spends a lot of his time doing litigation over. Remember, meal periods are 30 minutes before the end of the 5th hour of work or before the end of the 10th hour of work. They must be free of duties. The employee is entitled to leave the facility, et cetera. And then rest breaks are 10 minutes every 4 hours or major fraction thereof. So in a typical 8-hour day, which is what our law is really built off of, you're going to have an employee taking a 10-minute break in the morning, a 30-minute meal period, and a 10-minute break in the afternoon. Now that's the ideal arrangement. They don't clock in and out for rest breaks, only for meal periods if they are relieved of their duties. Again, as I mentioned, the wage order, all of these rules are outlined in the wage order for your type of business. If you go to the Department of Industrial Relations, you'll see the wage order options there. If you Google California wage order, you'll find the wage order. There's 16 of them that applies to your business, and you'll really be educated on the basics of wage and hour law in California. Also, I'll let Jeffrey speak to pay statement compliance, because that is a very important area in California law.
Yeah, this slide actually, go ahead.
Let me just interject, because we had a question on the meal about the meal period. I thought this might be a good point to bring in. It says, Alona Reddix asks, does the meal period need to start by and end by the 5th hour?
So essentially it has to start by the end of the 5th hour of work, but it doesn't have to end by the end of the 5th hour. So I tell employers that that meal period needs to start at 4 hours and 59 minutes. And the second meal period would start at 9 hours and 59 minutes at the, the very farthest out point. But typically you want to schedule meal periods maybe at 4.5 hours into the workday. But the end of the 30 minutes does not have to be within that window.
Yeah, this slide is just full of potential issues that I could file lawsuits on. And I mean, to pick up the invitation about talking about pay stubs, I think it was. So that Labor Code Section 226, it's worth looking at. It enumerates things that are supposed to be on the pay stub, on the the stub that comes with your paycheck, and all of those things are supposed to be on there. And if they're not on there, then you might have right away just a sort of what some people would call a technical violation, but you're going to be liable potentially, and you'll have to pay. And some of it can be cured. It depends on the provision, but not listed in 226 is the additional requirement under the California Paid Sick Leave law to also notify employees of how much sick leave they have available, either how much they've accrued and not used, or however you distribute it. And that's supposed to be provided at the same time as the pay stub. So sometimes people forget about that. If you're using a payroll provider, I've seen some payroll providers get it wrong. It's always good to work with your individual payroll provider contact to make sure that you're holding them accountable, so that employees don't hold you accountable for getting it wrong. They don't always know what they're going to be doing, in my experience. I mean, just more broadly here, the whole idea of employee classification as exempt or non-exempt is so important, especially for a startup. And it's a real legal analysis, because you might think that you have a professional who's a slam dunk, non-exempt employee, but there are various factors that must be met in order for that exemption to be properly applied. And it's the burden on the employer to demonstrate that the classification is proper. This can really, I've done a lot of analyses like this to try to make sure that employers don't get into trouble. It's not always an easy thing, and there are salary requirements, and there are differences between state exemptions and federal exemptions. Outside sales exemptions, inside sales. It's an unbelievably complex area. So just be careful if you're a startup and you think, oh, yeah, I'm just going to classify these people as non-exempt, and then I don't have to worry about this stuff.
Yeah, I'll just point out before we move on, one thing that comes up often, and I'm sure Jeffrey sees it, is the exempt employee in California, if you're a small business, must be earning at least $58,240 right now. So if you have employees that you consider to be exempt, or you're not paying them overtime and they're not keeping timekeeping records, they have to be making at least $58,240. Now, there's a two-part test, so salary and duties. The duties still have to rise to the level of exempt status, but the salary is an area where I see some employers tripped up. They might have employees at 50 or 55 and think, well, that must be enough. That's a good basic salary, starting salary. And that doesn't cut it in California. If they're not earning that basic minimum, then they are necessarily non-exempt. And that's a trap you don't want to fall into. So
yeah, I mean, even the duties test, it's different for state exemptions than federal exemptions. Every single bit of analysis of these has potential complications that, as a startup, you might not even know about.
yeah. Okay, next slide. All right, so how about founders and their minimum wages? Yes, so if they are officers of the entity, as we mentioned before, you must be paid minimum wage. As you know, current minimum wage is 14. It's going to 15.50 as of January 1st, 2023 for all employers in the state of California. This is where we talk about that minimum exempt salary. So if you're not paying yourself minimum wage or you're not paying yourself by the hour, you want to at least make sure you're making the minimum. And then if you have over 25 employees already, then the minimums go up. So it's 62,400 if you have more than 25 employees for it all exempts. All right. Let's see. Yes, founders need to draw a minimum salary. We had another good question about that. So these would be those minimums on this screen. So if you've got a business with 3 employees, the founders, if they're exempt, should be at 58,240 each. At least that's always been my advice. I don't know if Jeffrey has a different thought there.
No.
Okay, we'll keep going then. The next slide, we are going to cover diversity, equity, and inclusion. So a few things to focus on here. If you have 5 or more employees in California, you do want to be aware of discrimination avoidance. At 5, there's a lot of rules that become applicable to an employer. You are subject to pregnancy disability leave, for example, for a brand new employee. You've got to do harassment awareness training. But even from the very beginning, your hiring rules, firing, discipline investigations, there's lots of rules that apply to California employers with 5 or more employees. So there are free resources with the state to do the anti-harassment training. They're not particularly good, I will say, but they do meet the minimums. So all of your non-supervisors get 1 hour of training, and your supervisors have to have 2 hours of training, and that happens every other year. They must be trained within 6 months of hire or promotion into supervisor. So keep that in mind to focus on those rules, because even in small businesses, I see discrimination issues crop up. Seems like in the last 6 months, I've talked to 3 or 4 restaurants where one of the cooks was saying inappropriate things to another employee, and they said, well, we only have 15 employees. We don't have to do a lot of work with them. Well, yeah, but you do have to do harassment awareness training, and that's how you educate your employees about the fact that they need to treat each other equitably and fairly. They cannot bring up inappropriate topics. They can't make sexual jokes, innuendo. They can't touch or grab each other. There's a lot of things that are really not okay in the work environment. And the way employees learn that, if they've never been in a decent work environment before, is they go through those trainings.
Yep, I'll add on this topic generally that there are requirements here that startups might not be aware of. We didn't talk a whole lot about employee handbooks, but sometimes employee handbooks, if you decide to have one, may include policies about preventing harassment, preventing sexual harassment. Even if you don't have a handbook, the state of California has requirements for employers that they have to have these kinds of policies. And there actually are model policies that the state provides. And one of the requirements under regulations that went into effect not too long ago in recent years is that that policy has to specifically name every single protected category that's covered under the law. And it's so easy sometimes for people to carry over policies year after year, or pick up a policy that maybe a different business used without realizing that, hey, that's 6-7 years old. It's not going to comply anymore. I mean, this is a serious changing area of law where the Department of Fair Employment and Housing is going to be investigating it potentially on the state side, or else the EEOC on the federal side. It can just be an area with a lot of potential liability, and it's important not only to have the harassment prevention training that Lynn talked about, but also to make sure that you are very much aware of the policies that you are required to have in writing and required to distribute to your employees, and sometimes required to put on the wall. I mean, there's something called the labor and employment wallpaper, that really, as a startup, it's not just a question of going out and buying the poster necessarily. I mean, but the whole point I'm trying to make here is that as a startup, it might be easy to think, oh, I'll just pick something up, it'll be fine. No, you've got to be really careful with this area. It's an area of potential significant liability.
Yeah, we had a good question from the audience about where do we find those model policies that Jeffrey mentioned. So if you'd go to dfeh.ca.gov, that's the Department of Fair Employment and Housing of California, they will offer basic policy materials. They'll offer posters. They offer the training online that you can forward to employees. So there's a lot of materials now on that website. There are a number of documents that need to be given to new employees, and a lot of them are available from the state. So if you go to look for state resources, you will find those. As Jeffrey mentioned, many employers have those large all-in-one posters up in the break area, and that is a California and federal requirement that you do have those postings up. Because we have so many laws in the state, those posters seem to get larger and larger every year. You are also required to post the wage order. And so if you want to get those materials from the California Chamber of Commerce, for example, they're a great vendor of those basic materials for you. They'll also help you with a handbook if you don't want to hire outside counsel to do that. So there are a number of resources out there. The Chamber does offer quite a bit of materials online for you. Now, go ahead.
I'm so sorry. I didn't mean to interrupt, but I wanted to interject that even those resources are not necessarily going to be everything you need. I mean, employers also have to have basically a workplace safety protocol, especially for coronavirus, an injury and illness protection plan called an IIPP. And you're not necessarily going to find all of these in one place or get a poster that has it all. So, I mean, to the extent that you're relying on the poster companies or the chamber, that's great. But don't lose sight of other requirements related to Cal OSHA or whatever other. I mean, there's a whole gamut of different requirements out there for postings and what you need to do.
Sure. We had another good question. What if your employees are remote or working in shared workspaces? Where do you post? Yeah, in that case, you can email those policies out. It's nice if you have a Google Drive, maybe where they sit. It should be someplace where employees can see them anytime. So if you have a Google Drive or you use some kind of shared drive where you put those PDFs of all those materials, that's considered adequate for the most part. There might be a couple that you're required to send physical copies of, but really I recommend those email versions are fine. But again, I like to recommend that you have a repository where those documents sit. So someone's not searching their email, trying to find it. And that way you can send the link to a new employee and let them know, here's all our company policies, that's where they sit. But again, keep in mind, if you've got employees working in San Francisco, they're going to have a different minimum wage. They're going to have different notices that they have to receive because the city of San Francisco is quite active in legislation. They're going to have a different paid sick leave policy. So depending on how remote you are, just keep in mind that you need to always be thinking about those local rules that will apply. But definitely you can email out those policies. And I do get quite small employers asking me about, well, do we need to have a diversity policy? How do we handle equity, inclusion, those things? I guess I would say, to be honest, as a small employer, I'd recommend you focus on compliance on all the legal requirements first. There is materials available at the Department of Labor link that I put there. But I would say you first want to focus on anti-harassment. I work with a lot of employers that have spent a lot of money on DEI efforts, and they're not following the law on harassment avoidance. From my perspective, as far as being compliant and protecting your workers and also your supervisors, you really want to make sure you're putting those legal requirements on the harassment requirements first, and then certainly working on DEI as you grow. And there are lots of materials out there, not really a legal requirement, I would say, but something certainly to consider. Okay, we'll go to the next slide. How about immigration? Well, yeah, some employers will say, well, I'm so small, I don't need to worry about that. I'm not really going to do those I-9s. That's such a hassle. Who wants to review those documents? I don't want to bother them about that. Well, I will tell you there's lots of examples of small employers being subject to audits even today. I just had a client tell me the other day that they had ICE show up at a restaurant in Long Beach. Not sure if it was somebody tipped them off, but they did not have their I-9s in order. And so that becomes very awkward and it's difficult to respond in a timely manner if your I-9s are not up to date. So you do not want an employee on your payroll without a valid and thoroughly completed I-9. The I-9 is available on the internet. You print it off, you can do the fillable online. There's a portion for the employee and there's a portion for the employer. So only employees that have the legal right to work in the United States may be on your payroll. And the I-9 must be fully completed within 3 days of hire. So if you have an employee that tells you they don't have the right documents to show you, you tell them that you cannot put them on payroll without those documents, and to certainly keep you apprised of the situation. But you just want to make sure you are following those rules. You want to look carefully at the documents you're supposed to be requesting on the back side of that form or on page 2. Through October 31st, remote workers do not have to show you the documents in person. You can have them go to a notary and fill them out that way. Some employers are requiring them to do it locally with an individual, but there will be rules changing then about showing those documents in person at one point. And keep those I-9 records segregated from personnel files. They should be, in my opinion, in a separate binder, and they should be in alphabetical order. So if ICE shows up at your door, you have a binder, you can copy it for them, PDF it to them, show them exactly where you're at. You also want to keep a tickler file as far as any documents that are expiring that need to be where there needs to be some kind of re-verification on the I-9. You want to follow that very carefully. What if you're saying, or as we're talking right now, I have no I-9s on anybody? What do I do? After this presentation, you go to the I-9, print out the PDF, start filling them out for all of your workers with today's date. Never backdate an I-9. Be honest about your record keeping, but keep them in a binder nonetheless, and make sure you have everything up to date as soon as possible.
Yeah, that's also smart. Everything. So here's what I'll say. As a startup, this is an opportunity for you to build value into your company. Because you want to make sure that your record keeping here is right, that you've done it the correct way. And if and when the time comes that someone's going to buy your business in the future, guess what they're going to be looking at as part of their due diligence. Believe me, I've been there. They're going to be having people like Lynn or me going in and saying, well, did they do all this right? So you're not helping yourself or the value of your startup by not getting this right. The segregation of the documents is really important, not just with regard to I-9 forms. They should be segregated. I agree with putting them in a binder, but the personnel records, generally, you need to be very careful about what you're putting in personnel records to make sure that the records that might touch on protected categories like national origin or whatever it might be are in a confidential part of the personnel file. And that's one of the reasons for segregating this. But I mean, I think this is a really important topic for startups, because these are the kinds of things that if you do it right at the beginning and you maintain good practices down the road, your business is going to have greater value.
For sure. And just a touch on foreign workers, in order to work in the United States, they need a work visa. I have recently been getting more employers, due to the labor shortage, asking me about hiring workers in foreign countries who are working on a contract basis. You have to be careful with that. There are many third-party providers that will help you hire those individuals legally in their country of residence to do work for you. You certainly can do it, but again, they're subject to their local laws, their federal laws in their country. You might have to pay them. You have to pay the taxes, and you might have other benefits that you're obligated to pay. If you think California is a generous state when it comes to employees, you should try working in Europe or other places around the world where employees are entitled to all sorts of other benefits and contracts, and they really have very generous employment packages. So, don't be fooled by someone telling you, oh, my cousin, so-and-so in Hong Kong will do this work for us for next to nothing. You just want to be sure you're being careful about that and not breaking any laws in an international basis. Okay, let's go to the next slide. And how about overseas contractors? So that's what I was just speaking of. Just remember the laws of that country where that person is working will control the relationship. So in that situation, would you want to use a PEO? That might be the most reasonable approach. There's lots of entities out there that do this type of work. They will hire the foreign worker for you on their local payroll, and then you pay that particular entity for reimbursement of the payroll fees. That is my recommendation for the best way to approach that. Again, in some certain cases, California law might apply in this situation, so you want to talk to your counsel about that. But generally, US federal laws do not apply to workers outside the United States. So they are going to be governed by their local rules, and you have to observe those local rules as a employer, which is why you might want a PEO to step in and do that for you.
Yeah, overseas offices and working overseas can present a whole host of potential issues. If you have a US-based worker who maybe is called to an office in maybe an Asian country, they might be subjected to a certain type of questioning that is completely appropriate there as to their age, but that's entirely unlawful here in California. And so then what happens? Then the person comes back here to California. They've been reprimanded because of their age in whatever other country. It can be. There's a lot of potential problems here, and then we're talking. The slide is about overseas contractors, but don't forget that the contractor might decide, hey, I should have been classified as an employee in California. So these things all interrelate and present potential problems.
Okay, we'll go to the next slide. So employee records requirements, very important to think about the fact that you don't have to keep paper records, but you do need to have a very clear and consistent employee records. So minimum 3 years, the DFEH claims of discrimination or harassment can be made up to 3 years after the incident and events occurred. So make sure you are keeping those records for the entirety of the employee's relationship with your entity, as well as 3 years post termination. So you do want to be very careful about how you keep those records. And employment lawyers are always going to recommend that you only keep the required documents in the personnel file. Things like background checks and confidential information should be kept in a confidential file. Anytime you're doing any kind of investigation of the individual, you want to keep that in a confidential file. Medical records should always be segregated. And the reason behind that is it's fairly simple. It's that, if a supervisor wants to pull a file or look at an employee's record, if they're trying to decide whether they're going to promote them or whatever it might be, you don't want them seeing the I-9, medical records, any issues about, health benefits,
criminal background checks,
whatever that could be. So I recommend you just have a good system where you keep them separate.
Yeah, and I think I spoke over you. Criminal background checks are another one that really should be separate. It's it's probably going to be a good idea for startups to formulate a record retention policy and Lynn may have more information about this, but that record retention policy, it ought to be consistently adhered to so that you don't have like a situation where for one employee, you kept all of this stuff for years, but then for another employee, for whatever reason, you don't have it. It raises questions potentially. So if you have a record retention policy, then that can help you. Your record retention policy is going to be discoverable if and when you're sued. But records are going to drive a lot of what's discoverable in litigation. And so it's good to have what you need. Probably not good to have what you don't need anymore. But those are decisions to be made with counsel.
Mhm. Yeah, sometimes employers will ask me, well, we don't really have performance reviews. We say we do in the handbook, but to be honest, we never get around to them. And that's one of those things I think you need to be careful about. Employees do like to have annual assessments of their performance. They do like to know how they're doing, but don't wait until the annual review. If an employee has an issue, make sure you discuss it with them, document it, and put it in the file.
Yeah.
How many times have I had a client talk to me about wanting to terminate an employee? And I said, okay, well, send me the file. Let me see what's in writing. And they are quite unhappy to tell me that there is no file or there is no record of performance. There are no performance reviews. There's no write-ups, but they want to let them go. Maybe they've been there 5 or 10 years. Now we're looking at a kind of an awkward situation where this is a long-term employee and the employee is going to start wondering, well, why are you letting me go? I never knew I had any problems. I've never had any write-ups. I've never been disciplined. I've had salary raises every year. I've always been told I was doing a good job. So if you're letting me go now, there must be some other reason. And that's typically when an employee starts looking at things like, well, maybe it's discrimination. Maybe there's something I've complained about and I'm a whistleblower, whatever might be the issue. So again, if you're going to have consistent records on employees, you want to make sure you're documenting any kind of performance issues. It doesn't have to be voluminous. It doesn't have to be in any kind of official sense. If you have a sit down with an employee about an issue, send yourself an email and print it out or PDF it to their file. So you have a record of when it happened, what you said, how the employee responded, what you agreed on the go forward. Maybe it's a performance improvement plan where you're going to set up a specific check-in on a weekly or monthly basis to review how that employee is doing. You don't have to do that in every case because these are at-will employees. You can let them go for any reason or no reason, so long as it's not discriminatory or illegal. But it's always a good thing to let your employees know how they're doing. Okay, we can skip to the next.
Paid sick leave.
Yeah,
I mean,
that one, Jeffrey.
This is like one of my favorite topics in California because it has just been changing so much, and it can be a real challenging area for startups, for any company that does business in more than one community. California came up with its paid sick leave law not too long ago. It's been a few years now, and basically you have an opportunity either to allow employees to accrue paid sick leave, or you can front load a certain amount of hours. There are various options, and lots of record keeping requirements, and then a lot of individual cities and jurisdictions stepped in with their own paid sick leave laws, which are either more protective or different, or may not even allow you to do certain things that you can do under California law. And all of a sudden now, if you're an employer who has, let's say, a delivery driver who spends part of their time in Los Angeles, which has its own paid sick leave law, and part of their time in Santa Monica, which has its own paid sick leave law, and you have an accrual method, then how do you, it just all of a sudden it becomes this accounting nightmare. And then the question is, how do you account for that time on your books? How do you, for accounting purposes, year over year? But the bottom line is that this time is valuable. It's there. It's for the employees to use. They need it. And ultimately, it's probably going to be good for business to allow employees not to have to come in sick and infect everyone or to take the time. I mean, ultimately, it's going to be good for business. I guess it depends on your perspective. But one thing to bear in mind as a startup is that the employee really has a lot of latitude about how they can use it. They might call in and say, "Oh, I don't feel good." You really can't say, "Well, what's wrong? Do you have a headache? How bad is it? Can you show me a doctor's note?" No, you don't get to do that. You don't get to do that. There's some actual a potential liability for employers that try to try to do that kind of thing. So it's sort of it's an area where employers have to provide a lot of benefits without a lot of control over it, and comply with multiple jurisdictions. These are a lot of platitudes, and I mean, getting into the weeds is part of what is involved if you're going to be doing business in more than one city in California. You're going to have to sort through some of these issues. Just be aware of them.
Yeah. That's good advice. So the basic California requirement is 24 hours, and that's for all employees. It doesn't matter how large you are, whether they work part-time, full-time, double time. 24 is the minimum. If you want to do accrual, usually you're using 1 hour per 30 worked. So some clients would prefer to use that if they have a lot of part-timers. If you're using the accrual method, you want to just make sure that it's being handled properly through payroll. And again, like Jeffrey said, you've got to make sure you're complying in San Diego, Los Angeles, Santa Monica, San Francisco, Oakland. They all have their own rules on paid sick time. So you want to make sure those policies are accurate. When they're in the paid sick time realm, when they're using those hours, like Jeffrey said, you cannot ask for a medical note. But once those hours have expired and they are now just asking for additional time off, then you're back to kind of a non-sick leave rule, which is, you certainly can ask for medical support. And that's kind of how you avoid having someone who's maybe abusing the options. But as long as they're covered under paid sick time, then you have to be very careful about the questions you ask. And yes, they can say, "Hey, I woke up sick, I'm not coming in today." Or my son is not doing well and I have to go to the doctor, I can't come in. Those are why these laws exist. So as frustrating as that can be at times, those are situations where you're going to allow that employee to take that time off. And also just one more note, I see on a lot of pay statements that employers are not listing supplemental paid sick leave. So under COVID rules for 2022 through September 30th, all employers should have a supplemental paid sick leave line on the pay statement, and it should show how many hours your employee has taken this year for that extra COVID leave. And that was up to 80 hours of additional leave for employees who are suffering from COVID related issues or a poor reaction to a vaccine and so forth. Okay, next slide. All right, Cal Savers. So maybe one of our last topics here. Do we have to register? I got that question from a lot of clients recently because June 30th, all employers with 5 or more employees had to register with Cal Savers on the California website, and you must enroll your employees within 30 days of hire, or you can optionally offer a qualified retirement plan. So if you already have a 401k or something along those lines, you do have to enroll and register, but you can notify the state that you already offer a qualified retirement plan. All employers in the state with an employee tax ID number have been sent information about this program over the last year or two. So it shouldn't be a surprise unless you're a brand new entity. Employees are going to get auto-enrolled at 5% of gross pay under Cal Savers unless they opt out. Now, this is one of those areas that if you happen to employ individuals who don't speak English as their first language, you want to make sure you're giving them materials in their language. But otherwise, you are required to enroll them, and they are going to get 5% of that gross pay put into a retirement plan. These are portable accounts. They could be managed through the app, by phone, however the employee is comfortable doing it. It is something that is in their name. So it's a portable account, and it is something that every employer in our state with 5 or more employees must be doing. And a lot of employers were hoping that didn't apply to them, but we're at the point where it's down to even small employers participating. It was a rolling applicability. It started with large employers, but now we're down to even small employers. It's not going to go under 5 employees. So if you have less than 5 employees, you're subject to many fewer rules in this state, and you do not have to participate in CalSavers. You can choose to have a retirement plan, of course, but you do not have to have them. All right, maybe we're at the point where we should start taking questions, see what areas maybe we haven't missed, or if participants want to hear clarifications of any of these issues. We allotted about 20 minutes for that segment. And we know we covered a lot here. Hopefully you don't feel like you're drinking from the fire hose. If you are a small employer, you know, there are a lot of resources out there to try to give you guidance in that area. But do feel like you can find good resources on the internet to help you with those obligations.
Yeah, and to the extent there aren't any questions yet, I realized as we were giving the presentation that we didn't spend a whole lot of time on leaves, which is a huge area of California employment law. California offers various kinds of leaves for lots of different reasons. And one thing that I think it would be helpful for startup companies to focus on a little bit is what you do with an employee who has a disability or a perceived disability or who needs some kind of accommodation in the workplace. This is going to be for you. And it can be, we talked a whole lot about this, but it can be an area where it's very easy to make mistakes without realizing it. So as a startup, one thing to bear in mind is that if you become aware that an employee may need some kind of accommodation because of a disability, because of pregnancy, because of some medical problem, then you, as an employer, actually, then you have certain duties if you know about this. And one of your duties is to engage in what's called the good faith interactive process. And this is basically where you as the employer try to have a conversation with, hey, you know, we understand that you have this medical condition. We want to make sure that you're productive. Let's talk about that. How can we help you to be productive? And sometimes that accommodation might be a leave of absence. Sometimes it might be altered work hours. But a lot of, especially new employers, a lot of startup employers completely skip what's called the good faith interactive process. And the problem with that is that that's a standalone cause of action. So you get someone on plaintiff's side who says, aha, they didn't even talk about it. That all by itself can be the basis for a lawsuit. So, I mean, this is all in the context of what you do as an employer when your employees legitimately need time off for whatever it might be. Another leave area, and then I'm going to stop talking because I'm guessing questions might start coming in. Another leave area is, you know, giving your parents who are employees time off to go to their kids' school functions. That's actually another area where there are some rights that are afforded in California to employees who might have to go to school functions or to court ordered types of proceedings. Time off to vote is a leave category. So, I mean, one more thing of the many things to keep in mind as you're starting up and hiring is, okay, what are all of my commitments now when it comes to providing leaves of absence to the people that I want to be so productive here helping me?
Yeah, good point.
Anyway.
We had a question come up about what are the biggest remote work issues you're seeing? That's a great question. Um, I guess I have employers who are, well, certainly struggling with getting employees to come back to the office if there is an office. Um, and sometimes employers are having trouble determining whether an employee is being productive, whether they're actually working the hours they're saying they're working. They're questioning whether or not they can put in some kind of software on the laptop that tracks whether they're actually functioning and working during the day, or whether they're online shopping or doing other things. And that tracking software is an option for many employers. It might be expensive and it might be something your employees don't necessarily like. But there are options out there if you want to track that. I think what I'm seeing is just the challenge with keeping a workforce feeling cohesive after 2 years. Getting employees to have frank conversations with managers. It's a lot easier to sometimes have a conversation live than it is over a Zoom meeting. Recognizing that employees do kind of get to the point where they want to see people in person. From a compliance standpoint, I just see that some employers are not thinking about the fact that they've got to observe the rules where that particular employee works. And just thinking about the tax issues if they work out of state, making sure they are registered to pay the employee in that particular state. So those are some of the things I'm seeing, but I am having more and more clients resuming in-person work and asking employers to return. Some employees are holding out and are coming up with some maybe medical excuses why they can't return. I haven't really seen one that held up, to be honest, yet. I've had employees submit notes that say things like, kind of undisclosed mental disability, I need to be remote. Now, if the employee took the job when the job was in person, that really isn't going to work. If they were hired remote and they want to remain remote, it can become a bit more challenging to work through. But employees can be requested to report to an office, and certainly some employees moved away during the pandemic. And if that's the case, you might need to give them time to relocate. That's happened with a number of my clients' employees. But giving them some time, giving them a little bit of warning, obviously, before you're going to return back to the work office is a good idea. And, when people come back together, they're not really accustomed to working in a small environment again. They've been on their own for 2 years in many cases. And sometimes they need to kind of have a refresher on how to all get along. And sometimes that helps with, socializing and getting people to come in maybe on a staggered basis at first. So not everybody shows up on a certain day. So I've seen employers approach it many different ways, but I think we are getting to the point where some employers want to be in person and some employers are just going to remain remote, and that's okay. It just makes it a little more challenging from a compliance standpoint.
Another big remote work issue is business expense reimbursement. A lot of new startups might not realize that California has a law, California Labor Code Section 2802, which requires employers to indemnify their employees for reasonable business expenses. So if you've got people that are required to work at home and they're using their phone and their computer connection and their printer and whatever else they might have, you have to think about, are those business expenses that I ought to be reimbursing my employee for? If you don't, the employer might turn around and say, hey, you're getting an unfair benefit. Look, I'm giving you my paper. I might have to pay for a cell phone anyway, but you should have to pay for at least a piece of it. So think about that. Think about all of the, making sure that you're complying as a startup with your obligations in California to indemnify your employees for the reasonable business expenses.
Yeah, cell phone issues come up often, internet access, all those things. So, if you are relying on your employee to use a phone you must be reimbursing it. There is no way around that. If you would prefer to provide them with a phone, that's completely fine. That's the other option, but most employers would rather they allow the employee to use their own phone and then just provide them with reimbursement. And employers will ask, what do we reimburse? Well, I would say typically, I usually use a number of like $35 a month or something along those lines. But if the employee can show that the phone is costing them more for business purposes, so let's say they pay $100 a month for their cell phone and they use it for work 50% of the time. I would say in that case, then arguably you're paying $50 a month for that phone. Maybe in that case, you can get a better deal by providing phones to your employees. And so you can think about it that way. But the internet connection, those are all things that you want to make sure you have a policy that you're reimbursing. I see some employers providing $50 a month as a flat rate to cover everything, internet, cell phone, whatever. In most cases, that's going to be sufficient. But again, if the employee can show that they're spending more than that, then you have to reimburse the actual amount that they're spending on those expenses.
You know, one thought that popped into my mind as we were talking about all these various issues is EPLI. And that stands for Employment Practices Liability and Insurance. And the reason I'm bringing it up now at the end is that I actually have encountered a number of small business owners that had no idea that this existed. So it's worth checking out. I mean, if you have a insurance person that you've been working with on your other products, you might say, hey, is there a product out there for employment practices liability insurance that might be appropriate for me? Just one more thing to think about as a startup, as a possible way to protect yourself in the event that, for whatever reason, you run afoul of California's many employment laws.
Yeah, very useful to have EPLI. And I too have had many clients that wish they had it. And so it's very helpful. Again, just make sure, you know, your workers' comp is lined up. And that's one of those things that you might think, well, we're a small employer, we don't need to worry about that. That is one of those basic requirements of how, no matter how many employees you have, you need to have that policy. So there are about maybe 10 things you need to do as a new employer. And we talked about many of them today. But you know, it's very important you make sure your insurance is in order for your employees. You don't have to provide health insurance unless you have 50 employees. But many employers choose to do that because they know they can get better bargaining power through a broker. So that's something you can always choose to offer to your employees.
Yeah. I think it's kind of an exciting time to start up a business. But there's a lot to think about.
That's true. Very true. Yeah, I don't, if we have any other questions, anyone in the audience, or Jennifer, was there anything you thought we should have covered?
I think you all did an excellent job. I was also going to invite anyone who has questions to ask it once again in question and answer. I thought of one question that I think founders often think about, which is, you know, especially if you're creating a technological product, you're thinking about NDAs and you're thinking about employees moving over to other technology companies with your technology. And so I was wondering if you could expand upon sort of what types of clauses employers might want to think about including in their NDAs, specifically with an eye from a startup point of view, new technology.
Go ahead, Jeff.
Yeah, I mean, I think it's important to tailor them specifically to the needs of the business and not to overreach. I mean, one thing that you need to balance with NDAs are a great idea. You have to have them to preserve certain business assets. That's what they are. They're intellectual property assets, essentially. But if you get to the point of saying that the employees are prohibited from talking about without limitation the workplace, the practices, the businesses, you know, all of a sudden there are laws in California that give employees the right to talk about their wages, how much they are paid. There are laws that allow employees to complain and make complaints about workplace issues. And there are laws that say that it's unlawful for you as an employer to prohibit the employees from doing these things. So to the extent that you've got an NDA that's overreaching, or that might even infringe on labor, potential Department of Labor issues, where you're interfering with their ability to engage in collective conduct from a labor perspective. Those are all potential pitfalls. So any kind of NDA that you formulate, I mean, and Lynn probably knows a lot more about this than I do. I think it needs to be narrowly tailored, concisely targeted at specifically what it is you're attempting to protect, without overreaching and infringing on employee rights in a way that could get you in trouble.
Yeah, and just to, I guess, to touch briefly on non-competes, you know, California is in part the land of technology and innovation, in part because we don't have non-competes. We
Right.
illegal under California law.
Right.
So that allowed employees to move around much more freely from company to company. And in many other states, non-competes are legal. So they have to be properly tailored. So if you're doing business in multiple states, you might have a non-compete with an employee elsewhere, and you may not be able to have that same document here. So be wary of translating documents across the country that may not be appropriate. But here we do not allow non-competes. We do often see non-solicitation clauses, and you can protect, you know, the relationships you have with clients, where you don't want someone walking out the door and then soliciting all the clients the next day to follow them elsewhere. Now, there are certain things they are permitted to do, but there are limitations there with what you can restrict. But don't fall under the misconception that a non-compete is enforceable, even maybe just because you have a small business, or they're not going to fly, other than in business transactions where perhaps the departing founder is giving up some rights for a period of time. That's considered a slightly different scenario.
Yeah, I think if goodwill is part of the transaction, that can influence whether it's permissible. But it's a fraught area where even if you have done it the right way, you can still find yourself in litigation.
So I guess to tack on to that, you know, if an employee does leave, they go to another technology company, they bring your technology there, they implement it into the other company. What you're saying is you're not allowed to start off by saying you can't leave our company, but there are recourses for employers who lose an employee, but then the employee wrongfully takes the technology, just to clarify, right? So do you all handle that, or would you recommend shipping off to a different type of attorney?
I would not do that advice. I recommend, that's really a trade secret issue. So I would hand that off to an intellectual property lawyer, a litigator probably. But you know, yes, that trade secret is what we're trying to protect in those cases. So there are limits of what employees can do. You just can't stop them from leaving your business and going to a competitor. You can stop what they take with them. You can stop what they share. You can stop them potentially from stealing clients away using your business information or your trade secrets. But it does get tricky, and especially when you have employees moving cross country and maybe they have a non-compete in one state, but now they're moving to California. What's enforceable? So those non-compete rules get tricky, and that's why I usually turn that over to an IP expert.
Yeah, there are definitely labor and employment defense firms that have highly integrated trade secrets counsel who do employment and trade secrets, because it comes up a lot. But yeah, I mean, it's a specialized area. You don't want to just have, you want to make sure that whoever's covering that area for you, Jennifer, does have a strong background in trade secrets and probably some litigation in that area too, some litigation experience. In my opinion, that's probably what you want. And I think Lynn and I both could make recommendations potentially for people who do that kind of thing.
Yeah, but and our shop here as well has great cross integration. So good to hear. Just clarifying for everybody who's listening, who's like, wait, you're going to run off with my trade secrets and I can't do anything. Not
No,
quite
you can
saying
do
that.
something. You
And
can do something.
we also have a question from the audience. What is the employer's recourse if employee refuses to sign an NDA after employment?
Well, I mean, if it's a condition of employment, then you could probably terminate the employment relationship. Lynn, I mean, what do you think? Like,
Yeah, I would say that's something you want to offer, obviously, even, when you are hiring, that's part of the onboarding practice. But if they're refusing to comply with simple things like that, that's probably a bad omen. And it might be telling you that they're thinking about sharing some things. Now, if they're taking the position that the NDA is too broad, or affects maybe things they've already done in their career, like it's preventing them from sharing information they came to you with, then that would be different. So, again, I do see NDAs that are sort of all over the place that were intended for somebody who was looking into buying the business, and then somebody just converted it to an employee version. So, you want to make sure it's appropriate for the employment relationship. And I think that with that, we'll wrap it up. Thanks everyone for being part of it today.
Thank you.
Thank you, Lynn, Jeffrey. Great job.